ruled that the prosecution had not tendered the required evidence or grounds. Your Honor, those two rulings under the jurisdictions of our country are appealable to the High Court by law at the instance of the prosecution. But, Your Honor, the prosecution, because it is part of the executive under the Constitution, they appear under the executive chapter, only that it is supposed to be independent. They chose, instead of complying with the orders made by your honorable colleagues, they decided to deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts of the court, and for all practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office, but since Friday, after they were abducted at Roiro and Kiambu law courts, I had an intention to bring an important authority from the House of Lords, known as Bennett versus Horseferry Roads Magistrate, a decision from England. Bennett versus Horseferry Roads Magistrate. I can't remember the other citation. But it is one of the most important decisions that could be applicable to what is happening here today. I can't remember the citation. I remember the name of the case. Bennett, B-E-N-N-E-T, versus Horseferry Roads Magistrates Court. Chief Magistrates Courts like you. We shall furnish that decision as soon as we are able. Your Honor, in that decision, the basic issue was this, that Bennett had been, was somewhere in South Africa. South Africa and the United Kingdom had extradition arrangement where you could extradite persons to England. You know, but without getting Bennett from South Africa, pursuant to the extradition treaty, they decided to do a basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be there is absolutely no validity. In the ultimate, the House of Lords allowed the objection, Bennett. One of the best decisions one can read, and basically saying that, my senior counsel can read this again.
Yes, indeed, Your Honor. It's Bennett versus Horse Ferry. Horse as in horse. Okay.
Horse Ferry. You can read the one.
Horse Ferry.
Your Honor, some of these passwords are for the family.
Indeed.
Just read it.
We celebrate technology, Your Honor.
Then it was his horse ferry of magistrates and another.
Horse Ferry.
Horse ferry is like horse and ferry.
Yeah.
Magistrates court is another.
Uh,
There was a 1993 All England reports at page 138 and 151 House of Lords.
Yes, my lord. So that, you know, the basic finding by the House of Lords in allowing the motion was that this prosecution had to be prohibited, not because the state had no evidence, and not because the prosecution did not have sufficient to charge Mr. Bennett, but it needed to be stopped. Because once the prosecution and the police in England engaged in unlawful conduct and unlawfully arraigned the accused person, and abetting an illegality and the violations of the rights of the accused persons in terms of the protection of law, if such a prosecution were permitted to proceed. Accordingly, Bennett was discharged, not acquitted, in order to give the prosecution a chance. To arraign him to court in accordance with the law. And so that the court's hands are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at home. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Roiro and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Kahawa or committee? This one. Kahawa. And bring somebody to anti-terrorism court.
But the nature of the confinement, you are right to call it committee.
So that
thought we what
Yes.
I'm going to change country.
You will add anything after me. So you won't speak on that. So that, Your Honor, the issue, and it should bother the conscience of this court, because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa law courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution, in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government, would have come back. The courts in Roiro and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Roiro and Kiambu is possible before the Kahawa law courts? You know, we beseech you to make it very clear by allowing your objections, by saying that Kahawa law courts is also part of the Kenyan judiciary and will do its duty to protect the fundamental rights of Kenyans. Your Honor, my learned colleague, Senior Wamalwa, is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. And a contrary action before there is full compliance. And it is easy what that compliance is. So there is a contempt against this court in presenting these accused persons before you to stand trial over a matter that the prosecution chooses. We shall not go to the High Court, we shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were these. The prosecution was beseeching those courts to complete investigations. That's why they needed their detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? 36A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. This is Friday. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution that is the subject matter of the ruling of 4th of July is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can have them every other day, twice a week, to complete. Nevertheless, here, because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were made, only the High Court could vary that position. That if you wanted, you are dissatisfied with what those magistrates say, you needed to go and convince a judge of the High Court. Now these are such dangerous people that your learned colleagues at Roilo and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power, and the charges that they have preferred and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Ruiru and Kiambu got it wrong, get another interpretation on the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And Your Honor, we cannot have so that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Second, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important, because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Yes. Yes, there is a proviso that is made that that is Section 2 actually, that with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary, because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included. That we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions, and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Yona, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity waged by Kenyan citizens across Kenya, there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism, everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. You know, the related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. Your Honor, this is absolutely important for a very simple reason. Your Honor, for purposes of the trial, it must be done in an open court. Your Honor, the trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. My Lord, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about 4 facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa we deal with terrorists. If for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution, last of the CPC, sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Preventions of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Preventions of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with leave of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we read, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. We were dealing with 36A, the other side. Yona, what is it about this section? Yona, what these sections is based on is because those specified and to national security, that despite Article 50 of the Constitution, to prosecute the case without availing of the that is an absolutely important issue. Because one of the most important safeguards, you get the materials for your trial. So when you try a terrorist,
persons before you are currently enjoying orders of this court in reference to their liberty. This is a person to miscellaneous criminal application E290 of 2025. The Chief Magistrate Court at Kiambu, for purposes of record, by the two. One is arson, contrary to section 332 of the Penal Code. The second one is malicious damage to property. Of the Penal Code. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice on the public document. All I am trying to say, in the interest of time, is that the offences that the persons before you had allegedly been brought before the Kiambu court on a miscellaneous to have custody of them were serious offences than the offences that they have allegedly been brought before you for plea taking today. And I am not in any way saying that offences are